We are live.
Oyez, oyez, oyez. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Thank you, Mr. Bailiff Ramirez, for getting us going. We're here this morning at 10 o'clock to hear the case of 07-19-00286-CR, Becker versus the state of Texas. Normally we'd ask for announcements, but given that this presentation is dedicated just to your case, that case, we'll forego the announcements. I do want to thank both Mr. Ford and Mr. Hampton for agreeing to present through Zoom. These circumstances have caused all of us to rethink normal, and I think we are coming through it pretty well. I don't know if this is the first Zoom argument you had. I think Mr. Ford may have had one before, but Mr. Hampton, I don't know if it's your first one.
Yes, it is.
Okay, we are running live on YouTube as well. So with that said, again, we're calling 7-19-00286-CR, Ashley Becker versus State of Texas. Mr. Hampton, you're representing the appellant and you have the floor.
Thank you, Your Honor. May it please the court, I represent Ashley Becker. Ashley Becker has suffered and been deprived of many of the basic rights that anybody else has. Before we wrote the Bill of Rights, we had the Declaration of Independence that promised that we are endowed by our Creator with certain inalienable rights, the right to life, liberty, and pursuit of happiness. And Mr. Becker, for a variety of reasons, cannot do that, primarily due to an unfortunate Court of Appeals opinion. But before I get to that, I want to briefly kind of clear the brush as to arguments I am not making. The state sets up really about 4 straw man arguments. One is that the state, it argues the state has an interest in deterring crime. Never said it didn't. Of course, a state has the police power to do that. Not the issue. The issue is whether or not that interest is rationally related to what they're doing with a licensed handgun owner. Another argument is that only a person who is within one of the 3 who are regularly engaged in criminal activity is liable. Well, I agree if we're talking about the Section 71, Chapter 71, the engaging in organized criminal activity statute. But it's not true under Chapter 46. So I agree, only the 3 people who or the police have probable cause to believe are regularly engaged in criminal activity are the ones that are to be liable. So the question becomes, what's Mr. Becker doing here? Third one is they make the argument somewhat extensively that Section 4602, the applicable section that's at issue here, does not make distinctions based on race, alienage, or national origin. Never said it did. This is a complete distraction. So if you hear it, tune it out. It's not what I'm arguing. Finally, they make a separate section about the legislative history, where I've included or noted that this court, in this case, is the first opportunity for any court to construe the very statutory provisions that are involved here after their amendment in 2015. The state argues, well, they only altered one section of it. They're missing the point. That's true. but it reflects a legislative intent that licensed handgun owners have elevated rights. They went from concealed weapons in 2007 when Flores was decided. At that time, an unconcealed handgun was equated with criminal activity under the statute, under 4602. 2015, just the opposite. An unconcealed handgun is equated with legality. In 2007, when Flores was decided, licensees were recognized only in the inapplicability section in 4615. Well, today, they are expressly recognized in the UCW statute itself. So the debate regarding its House Bill 910 was the change. And my position is that it's notable in that it reflects and is consistent with the legislative view of people who are licensed to carry weapons, going from concealed to open carry. So the primary issue in this case, or the focal point, needs to be on ex parte Flores. And I detail on the brief, I won't run over all of it, but Flores was fundamentally wrong. And it's wrong because they did not take into account how the phrase or the definition of a gang even wound up in the unlawful carrying of a weapon statute. And that's detailed to fine detail. And all of those statutory provisions are included in the appendix. And what the legislature did, and I've had a lot of experience at the Capitol, this is not unusual. Nobody means, there's no ill will or bad faith. It's just that at some point, somebody decided, hey, let's take this provision out of Chapter 71, where it works perfectly constitutionally, no problems, long-standing statute, and just put it in the unlawful carrying of a weapon statute. And so,
if you could answer me a question real fast.
Sure.
The statute which Mr. Becker is being prosecuted, and of course this is appeal from a habeas situation, so there has not been any type of actual trial or conviction, but under the statute being prosecuted, what are the elements in your view to gain a conviction?
I don't think they can. I think the statutory scheme is unconstitutional.
What as the statute is written now, what are the elements?
The elements are you do you have a weapon? Do you have a handgun? And are you a member of a gang? And that's it. Now, the element that they would have to prove under Flores and under a plain reading of the statute is that Mr. Becker is one of three people who's a member of a group who regularly engages in criminal activity. And instead, what you have is a law-abiding man. This is a middle-aged man who's got no record, and he managed to get a concealed weapons permit. And I put in all of the things you have to do to get that. Can't be a felon, can't have other constraints on you. You got to pass, you got to show your ability of safety and so on. And he did all of that. And we, the state of Texas, have awarded him a license. And yet, unlike any other licensee, he's treated like a criminal. And that's what's wrong with this. And that's why that
relates to one of the questions I had. He has a license, and you indicated that the background check to get a license includes investigating whether or not you've been involved in criminal activity, you've been convicted. Is it criminal activity or been convicted, or is it both, or?
It's a little bit of both, actually, but it is convicted.
Okay. So he has a license, which indicates that he hasn't been convicted or has not been involved in criminal activity. But the state, I guess that's my concern, is how does it play with the gang member?
Yeah,
Because the state is arguing you have to be one of the three or more that are involved in criminal conduct.
right.
So, and the record indicates that he's been stopped several times.
That's
I
right.
think he said, including in El Paso, and apparently this is the only prosecution.
Yeah, it's his third time of being arrested. This has repeatedly happened to him. And yes, the state would have to prove that, but you have to ask the question, what are we doing here? That's why I'm asking for the remedy that I'm seeking. It's not enough to get him acquitted. He could have been acquitted on the other two. Anytime this guy gets on his bike and just wants to ride around, he's got probable cause written on his forehead. They can stop him and arrest him at any time. I have asked the question, and I would love an answer from the state if they know, which is the DPS has a database of everybody that they have decided is a gang member. They also have a database of everybody who's got a license to carry a weapon. All they have to do is look at these two databases. All they have to do is collate them and then find the people, because the likelihood is they've got a license to carry, so they're probably carrying a weapon. And since they're a gang member, we can get them. And he's repeatedly been singled out for changing or bumping against the white line, traveling too slowly in a farm to market road in Lubbock. You know, we don't have the pretext doctrine, but you know that that's what that is. And he needs to be free of it. And that's what's unusual in this case is, and why I'm making as applied arguments, is the remedy that I'm seeking is an end to this behavior. Flores, which the state is completely dependent on, is wrong. And this is self-evident in this case. If Flores was the protection that the state claims it is, in other words, we don't prosecute people unless we know they're one of the three people regularly engaged in organized criminal activity. Really? Well, Mr. Becker is exhibit 1, 2, and 3.
Mr.
That's not
Hanson,
true.
I've got a question for you. If I read Flores correctly, it's my understanding that there's some precedent from the Court of Criminal Appeals that at least at this stage in the proceedings, we don't look at an as-applied challenge. We only look to facial challenges. I wondered if you had any response to whether you think Flores is incorrect on the law on that or not.
Well, Flores predated Perry. Ex parte Perry is your last word on that. And it's not clear. But my position is that you can consider as applied arguments. You don't have to get there if you find it's facially unconstitutional. It's not necessary that you reach the as applied if you do that. But if you do, what is the standard for being able to consider as applied arguments? And put another way, why do we not look at as applied arguments? We don't look at them on the basis that we haven't had a trial. The reviewing court doesn't have any facts. That doesn't apply in this case. We stipulated to the police reports. So you have all of those facts, including the facts of and circumstances and the case against Mr. Becker in this case. So you've got that. The standard.
Mr. Hanson, even the CCA said they'd carve out some exceptions, which you're discussing. One of the exceptions to the allowing interlocutory appeal that as applied and consideration of this is double jeopardy. Why do they allow consideration of double jeopardy? Is it related to having to go through a prosecution and double jeopardy is sufficiently important to not even expose the person to a prosecution. So that's why it can be considered.
Right. Double jeopardy is the best established circumstance of an as applied challenge you can bring on appeal. It's very well established. It goes back decades. Why? Why are you able to do that? Why is that so unquestionable? And the reason is, and I cited, you have to go back to 1957 actually, but it explains it. And the explanation is that we're not going to make someone, and I'm quoting, compel that person to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though he's innocent, he may be found guilty. And that is exactly why the as applied challenges in this case can be met, because that's exactly what I'm trying to prevent. This man is repeatedly harassed under the fiction that he is protected under Flores. Flores is false. It is a mirage, and it never considers the interplay between Chapter 71 and Chapter 46. But
I guess your suggestion would be we would consider as an applied here because, and this is just talking, not indication of a point of view from my side, but your suggestion would be that to the extent the First and Second Amendment of the United States Constitution, freedom of association, freedom of travel, right to carry a weapon, applies, it would bar the prosecution because it would render the criminal statute, it would negate the criminal statute. There would be no criminal statute to prosecute. Is that what you're arguing?
Absolutely. That's the full remedy this man can have to end what's been happening to him. If there is an opinion that gives him the remedy that I've asked for, he can carry that with him on his bike and show, and I don't believe he'll be prosecuted ever again, so long as he is not committing any crime, so long as there's no probable cause. There is, he gets arrested. Otherwise, he gets to be free just like any other licensee in this state. That's my position.
Given the status of the case, is there any evidence of record? Again, I know it has the trial, but is there any evidence of record indicating whether or not Mr. Becker has any type of unlawful activity while a member of the band?
Only the arrests that are just like this one.
But there was no prosecution there.
I'm sorry?
There were no prosecutions there, though, correct?
Right. Well, one just sort of pended for a while, but yeah, that's correct. He, in 2012, when he failed to signal intent prior to changing lanes. So they arrested him, and in accordance with what he's supposed to do, he shows him his concealed weapon permit, and then they arrest him for that. Then they release him, and they book him in and release him, and they never prosecute him. That's 2012. In 2016, he crossed a solid white line, again in El Paso. And that,
Let me ask you
they
this.
cited him for traffic violations and released him.
Yeah, let me ask you this, counsel. I'm assuming that your client was indicted.
You're
Correct.
assuming my client, I'm sorry?
I'm assuming your client was indicted, correct?
My
There
client was not
there wasn't an
indicted.
indictment issue, correct?
Yeah, there's no indictment issue.
There is no indictment in this case?
Just, it's an information, it's a misdemeanor.
Okay, so it has, okay. So it hasn't gone before a grand jury to determine probable cause. Has there been any type of probable cause hearing involved where anybody could determine whether or not there is evidence to support the state's argument of how you interpret criminal street gang, i.e. that he's got to be part of the three or more that's actually involved. Of course, if you had a probable cause hearing, maybe they would have presented some to that effect, et cetera, et cetera. But is there anything like that here?
No, not really. We stipulated to evidence. There's not a motion to suppress, because that's not what we're seeking. We don't think that's enough to suppress the evidence, assuming that it could be. So that's the reason for the pretrial writs. As far as arguments and so on, we did that by stipulation. So the state put in, I think, again, stipulate. I agreed, they agreed to certain things. So we all agreed to it. And one of them is the DPS's publication about gangs in Texas. So we have that. And then we have the police reports. And I think there were some other items. I'm blanking on them right now, but we all stipulated to basically, if we were going to have a hearing, we just saved ourselves, a lengthy hearing by just putting in the documents. So that they're all in the record. They're all in the clerk's record. And this was very, very much argued by brief. So it is in the clerk's record. I filed many things, and they're all in the clerk's record. And so did the state. So we
Mr. Hampton, is your problem with Flores the definition of or how street gang is applied specifically in this case?
It not just applied, it renders that portion of the statute, its interplay or its presence in chapter 46 is unconstitutional on its face. Where it exists in chapter 71, it's perfectly constitutional. It's worked very well. What happened was the lawmakers simply took it and dumped it in that section without realizing the consequences that we've seen now with Mr. Becker. Oh,
thank you, counsel. And you will have 5 minutes vote.
okay.
We can reset the clock. There you go. Mr. Floor.
May it please the court, counsel. Honors, appellant has brought 7 facial constitutional challenges and 7 as-applied challenges to the UCW by gang member statute. Before analyzing the constitutional challenges, it's first necessary to consider proper statutory interpretation. And that, of course, is where the ex parte Flores case comes in. Appellant has asked the court to interpret the statute in the ways that he knows would render it unconstitutional. That is not a proper manner of conducting statutory interpretation. Instead, if a statute is capable of 2 different constructions, one that sustain its validity, courts apply the interpretation to sustain its validity. And Chief Justice Quinn answered a question that you asked. You were talking about what are the elements of the offense of the UCW by gang member statute. You must have possession of a firearm in a motor vehicle by a member, and that, of course, is where the ex parte Flores interpretation comes in, of a criminal street gang, and that's where ex parte Flores also comes in. The first portion of the ex parte Flores case, it analyzes the proper construction of the term criminal street gang. The Flores court determined that 3 or more persons meet the definition of a criminal street gang only when they continuously or regularly associate in the commission of criminal activities. The statute does not apply to 3 or more persons solely because they have a common identifying sign or symbol. The ex parte Flores court next analyzed
it requires both, doesn't it, counsel? It requires both. It requires a common symbol, and it requires, well, what you're arguing, continuously or regularly associate in the commission of criminal activities. Honestly, you're looking at that statute, and it says who continuously or regularly associate in the commission of criminal activities.
Yes, sir.
What's associate?
Associate gets to the interpretation of the term member, which when taken together with the definition of criminal street gang indicates that gang member must be one of the three or more persons who continuously or regularly associates in the commission of criminal activity. So in other words,
Associate means they're a party to it, they've committed, or they associated. How definite is associate in view?
It means that the person that must be a participant either directly or as a party to the commission of one or more different offenses.
So, Mr. Ford, what is the underlying offense in this case that definition would apply to?
Getting to the as applied constitutional challenges, and this is where the conditional stipulation of facts comes in. Obviously, of course, it's conditional because our argument is that the court should never get to the as applied challenges. But if the court were to get to the as applied,
hold on, Council. I think Judge Park, of course, she can correct me if I'm misstating. She asked, what are the underlying crimes or offenses that go with regard to continuously or regularly associating with the commission of criminal activities? Is that what you're asking, Judge?
Yes.
Yes, Your Honor. And in the conditional stipulation of facts, the LSO offense report shows that appellant makes decisions regarding the trafficking of firearms, narcotics, or other criminal activity associated with bettering the criminal organization, the Bandidos outlaw motorcycle gang in this case. So those would be, even though those are not charged in the information itself, because they would be extraneous offenses, those would be the underlying offenses there in the continuously or regularly associated in the commission of criminal activities that the state would, if we end up having a trial in this case, the state would be proving up, Your Honor.
And those are allegations particular to Mr. Becker?
Yeah, yes, Your Honor. That's what the state will be attempting to prove up through the testimony of deputies, Deputy Macias and Cisneros, Your Honor.
Curiously, it was related to something that I asked opposing counsel earlier. If Mr. Becker, if the Lubbock Sheriff's Office, SO, I guess, has that information with regard to Mr. Becker, why does he still have a concealed carry license?
Your Honor, that is an excellent question, and I believe that would be a very appropriate question to be asked on cross-examination or on direct examination for that matter. Unfortunately, I don't have the answer to that question there, and of course, it would be outside the record. But Your Honor, I don't know the answer to that.
What information that the LSO has that you just mentioned be available to the law enforcement officials in El Paso that stopped them?
They stopped him years earlier, so they may or may not. I don't know the answer to that.
How about the other times I think it was indicated, counsel indicated he's been stopped in the Lubbock area as well before. If they had that information, how come they didn't act on it? And I'm not saying they should act on it. I'm just wondering the comparison of concealed carry and then the statute is interesting to me.
Yes, Your Honor. And that is exactly why, even with the conditional stipulation of facts, why an as-applied constitutional challenge should not be determined in pretrial habeas review, because the only proper way to answer all these questions, all of which are interesting questions I believe should be asked during a trial on the merits, is to actually have a trial where the deputies can be taken on both direct and cross-examination there. But until that time, no amount of stipulations could take the place of direct and cross-examination of both sheriff's deputies and any other sheriff's deputies or somebody from DPS that either side wishes to call. A question was asked about is discussed during opposing counsel's argument about the different lists, about gang member lists and the licensee list. Just like all these other questions, that'd be a very interesting question to ask during a trial. But until that time, we don't have the information in the record and why an as-applied constitutional challenge should not be considered on the merits at this time.
Mr. Ford, let me ask you a question related to what you were saying just a minute ago. If I understand you correctly, you were saying that the defendant here in this case, that your burden of proof is to prove that the defendant was engaged in other illegal conduct, that it was not simply membership as a part of a group. Given the definition, the way it's included in 46.02, are you not also required to prove that during the commission of these other illegal acts, he was in possession of a firearm at that time in order to satisfy the full definition?
Your Honor, the state has to prove that the defendant was a member, which would get into the continuously or regularly associate, but the state would not be required to show that he was actually possessing a firearm at the time of committing the extraneous offenses. So you'd only have to be proving up possession of firearm at one point, and then the extraneous offense evidence would be proving that he was a member of a criminal street gang.
And I guess that's where my question, we may loop back around to where we started then, how membership is something that can be given up once they're alleged to have committed a bad act in the past. Is that something that's just on his permanent record where anytime he's prohibited from carrying a gun at that point forward?
At the time of the UCW offense, if he were no longer a member of the Banditos or any other gang for that matter, then he would no longer be subject to the UCW by gang member statute. He must have a status as a gang member at the time of the UCW offense.
But the definition of member of the gang means that he is at least continuously or regularly in committing crimes that fall under 71.02.
He is not required to commit crimes that fall under 7102, but he is required to be continuously or regularly associating in the commission of criminal activities. But for 4602A12C does not specifically state that it must be one of the offenses specifically enumerated in Chapter 71.
And there's not a requirement for convictions, apparently. It's engaged in criminal activities.
That is correct, Your Honor. And Your Honor,
with regard to your gang, is your prosecution, in order to satisfy the definition of street gang, related to wearing of the common sign or symbol, or is it related to the identifiable leadership?
Your Honor, in this case, I believe that we have a common identifying sign or symbol or an identifiable leadership. Of course, it isn't alleged, and we haven't narrowed what we have to prove in the information. We can prove any one of those. I believe that the facts of this case show that we can prove identifying sign or symbol or an identifiable leadership, any which one or all of them that we choose to prove there.
Based on your argument, it sounds though that the statute that you read, the statute is saying that if anybody is wearing this common identifying sign or symbol, then and the rest of the elements of criminal street gang are satisfied, then anybody who wears that symbol is a criminal.
They have to, well, that's why the ex parte Flores court interpretation of the UCW by gang member statute is so important, because which helps cure all the alleged constitutional issues. Because as appropriate here, the defendant, the person wearing the identifying sign or symbol must be one of the three or more persons who continuously or regularly associates in the commission of criminal activity. So in other words, I'm sorry.
It sounds like that you're creating a presumption, though, that if you wear this common sign or symbol, if you wear the bandito patch, if you will, then you're a criminal. It's presumed you're a criminal if you wear that patch.
Your Honor, I am absolutely not making that argument there. In fact, as shown in the ex parte Flores case, law enforcement may not arrest a person merely because they recognize gang signs or symbols. Law enforcement must also determine whether the person is carrying a handgun in a vehicle and whether he or she continuously or regularly associates in the commission of criminal activities. So the law enforcement has to go beyond just saying, oh, this person has a symbol of, example, an outlaw motorcycle gang. They can't arrest them based on that alone. They have to determine if they're regularly, continuously or regularly associating in the commission of criminal acts.
Is part of your burden at trial then to prove that members of the Bandito organization as a whole criminally engages in criminal activities regularly, and in order to be a Bandito, you've got to do that too? In other words, that's a condition of being part of the Banditos. You've got to engage in criminal activity.
The first portion of that I agree with. We do have to show that the Banditos as a whole qualifies as a criminal street gang, but we don't have to show that they that the person necessarily subscribes to that. We just have to show that that person is one to three or more persons within Outlaw Street motorcycle gang that continuously regularly associates in the commission of criminal activities.
The involvement in commission of criminal activities, does that have to be their sole purpose, or is that just got to be like some purpose or a minor purpose in your view?
It definitely has to be some purpose. I don't know that has to be their sole purpose in there. So they could certainly do other activities other than just commit criminal activity. Of course, that's why it gets into the continuously or regularly. I found a definition of continuously, which means in a continuous manner without interruption. Regularly means on a regular basis or a regular manner or on a regular basis. So it must be something that's admittedly somewhat, but not their sole purpose.
What's the nexus that's required between a particular defendant and other members within an organization? You've got some organizations that may have 1,000 members, 2 of which he's never met and are performing, or 3 of which he's had met and are performing regular and continuous criminal activity. Wouldn't that qualify anybody to run afoul of the statute by merely their association with the individuals in the group?
Your Honor, and that is, of course, is exactly why the ex parte Flores' court interpretation of the statute is so important. Because which gets into the freedom of association argument that opposing counsel has raised. It does not implicate the freedom of association because it does not prevent gang members from gathering to engage in any activities protected by the First Amendment, speech, assembly, petition for redress of grievances, for example. The only prohibition is that gang members may not carry a handgun in a vehicle. So in other words, it doesn't implicate the freedom of association because a person can still gather with other members, even other members of, like here, the Banditos. The only prohibition is that they can't carry a handgun in a vehicle there. As for
well, it also seems to me like you might have a notice problem along those same lines, because if an individual is a member of an organization and doesn't have any personal knowledge of the acts performed by other members in the organization, then it would be difficult to charge them with a crime for carrying a handgun.
In a particular case, I agree, which would be an excellent as-applied challenge there if the person were unaware and unassociated with the criminal conduct, which is why, of course, the definition of member in criminal street gang is so important, because they can't just merely be associated with the criminal street gang. They must be a participant in the activities, in the criminal activities of the gang there. And your honors, I believe I have talked about every issue that I intended to talk about. So unless the court has any further questions, I will get back to balance of my time.
Just out of curiosity, I know that let's assume a law enforcement agency, and we know that it's made of human beings, and human beings do things that are wrong time to time. That's in our nature. Law enforcement agency has 3 officers that have committed criminal activities. And I guess criminal activities could also consist of speeding because it doesn't give a category of how egregious they have to be. But let's say they speed. Now, law enforcement officers also wear a common symbol, the badge representing where they work. If you are a member of that law enforcement agency, are you a criminal street gang if 3 or more of your officers get involved in criminal activities?
Your Honor, that's why the statute Yeah, I don't believe Ex parte Flores came right out and said this, but they did strongly suggest that there must be a connection or nexus between the defendant's commission of the criminal activities and his gang membership. In particular, in Ex parte Flores, there's an example given a political party that engages with an identifying symbol, engages in voter fraud every other election in there. And they talk about if that is part of the activity of the political party, as opposed to merely a few participants within the organization, then the political party there would be considered, if that's a regular activity of the political party, then that would be considered a criminal street gang in that instance. Likewise here, it must be an act of the gang itself here. So it can't just be 3 or more, as opposing counsel put in his brief, miscreants within the organization. It must be part of the organization's goals itself there. So even if there are 3 bad actors within, as you said, a law enforcement agency, that would not make the law enforcement agency itself a criminal street gang.
And that's Flores.
That does come from Flores, that example of the political party. Yes, sir.
And what do they base that on? How do they get that construction from the statute?
They base that on the definition of both criminal street gang and member there. The first portion of that talked about where they had to interpret the criminal street gang portion of the statute. They determined that 3 or more persons meet the definition of criminal street gang only when they continuously or regularly associate in the commission of criminal activities. The statute does not apply to 3 or more persons solely because they have a common identifying sign or symbol.
But the statute itself does not say that the accused has to participate. There's nothing literally in the statute that says that. That's Flores interpreting it.
That's why their definition member is so important, because when there's 2 or more different ways of interpreting a statute, one of which sustains its validity and one of which does not, you determine the interpretation that sustains its validity there. If a person chose to, they could read the statute as in a way, as opposing counsel has done, that does not sustain its validity, but that is not proper statutory interpretation there. The proper statutory interpretation would be to interpret member as one of 3 or more persons who participates in the commission of criminal activity.
Right, but if the legislature had wanted to use the word engage in 71.01D in place of associate, it could have, right?
It could have, Your Honor, yes, sir. But associate in this instance, in terms of the proper entirety of the statute, it shows that associate means participate.
But then hasn't the legislature elsewhere used the terms engaged and participate and party and things like that specifically?
They have, Your Honor, but.
And then the rules of construction, if they've used those specifically elsewhere and they don't use it here, are we required to assign that specific construction when they use a different word?
In the absence of any definition in the statute itself, we apply a definition of sustain its validity there, and that's why the associate can be interpreted as participating as either as a direct actor or as a party to the commission of the other offense.
Counsel, thank you. Your time has expired. Appreciate your argument. Mr. Hampton, 5-minute rebuttal.
Yes. As a matter of statutory construction, take a look at what Flores actually did on page 16 of my brief. I tell you what the statute says now under Flores. It's not what the statute says. It's what Flores says the statute says. According to Flores and according to the state today, criminal street gang means only those people who are members of a group with a common identifying sign or symbol who continuously or regularly associate in the commission of criminal activities, so long as the group has members at least 3 in number. All other members of the same group who are not among the 3 or more persons who continuously or regularly associate in the commission of criminal activities are excluded from this definition. That is classically wrong statutory construction. You're adding stuff to a statute, adding it to try to save it from its obvious unconstitutionality. Let me mention two other things. The state's whole case is extolling the virtues of Ex parte Flores. Ex parte Flores, according to the state, over and over again, protects everybody except those three people who are irregularly engaged in criminal activity. And let me say this, insofar as the state, and I may have misheard, but if the state even implied that Mr. Becker is in any way engaging in organized criminal activity, they sure didn't charge it in the information. Who are the other two people? You won't find it. Mr. Ford was not at the hearings that we held. The prosecution was given everything, any and everything you want to prove. And that's in the record. And this other stuff is not. Flores is not, it's wrongly decided, and it is a mirage to people like Mr. Becker. If it was such a protection, why was he arrested? Why is he being prosecuted for unlawful carrying of a weapon? There's nothing else here. The entire discussion about sufficiency and what the state would prove and not prove, all of what they would prove and not prove is regularly found in every prosecution for engaging in organized criminal activity. That case law is well developed. It's got no application except for this unconstitutional provision that pulls in anybody who can be deemed a gang member. And Flores provides, if Flores provided any protection, Mr. Becker would have been permitted to go on his way. Instead, Flores is used over and over again to be able to arrest handgun licensees who are law-abiding, who aren't doing anything but riding on their bike, which is all he wants to do. And we all get to do that.
I find it interesting that if Mr. Becker is involved in such egregious criminal activity as suggested to satisfy the street gang definition, that the state is only prosecuting him for possessing a weapon. I see.
Yeah, that he's licensed to carry.
Yes.
That's it. I mean, on the one hand, you know, Mr. Becker, we confer upon you this right.
And I'm not suggesting he'd be prosecuted for anything else. I find it interesting, somewhat ironic.
It's ironic. It's contradictory. It's one of the reasons that this statutory construction is unconstitutionally vague. You tell a guy on the one hand, congratulations. The minute he gets on his bike, if he's got the wrong bumper sticker on his car, then he gets to be pulled over, and God help him if he's got a license that he earned, because he's going to get arrested, just like in this case.
And they're using that symbol to kind of gauge who to stop. They're using the symbol with the bumper sticker, whatever, to gauge who to stop.
Absolutely. If he had, you know, I support so-and-so for president, you know, he's not going to get pulled over.
Well, it depends on where you are in the nation. You may get pulled over.
Well, that may be true. But, you know, Boy Scouts, Girl Scouts, I support love and peace or whatever. No, it's being in a group that law enforcement doesn't like. I agree. They've got police power, and they need, you know, we have that. But this is the limit. And the cases that I cite in there, this isn't the first time that this has happened. This goes way back all through American history, and that's developed in the brief.
Thank you, counsel. Your time has expired, and as you know, you've argued before courts before. Judges and courts have often played devil's advocate, so we do that as well. Please do not take any of our questions or our comments as indication of a position. We just often, more often than not, we ask just to kind of peek your responses, try to get, see what you're going to say. But with that, we want to thank you again for participating in this oral argument via Zoom. Both of you were quite audible. We appreciate your willingness to help move forward given the circumstances that the state and the nation is undergoing. The case is submitted and you are excused, given that you're probably home or something already, but thank you, and we will be in recess until this afternoon.
Thank you.
Thank you.